Good afternoon, everyone. My name is Chris Letty, and I want to take this opportunity to thank the Massachusetts Staffing Association for their work in putting this webinar series together. I'm sure each of you will see it as a value add to your company and or your responsibilities. I am presenting today with Sarah Davis. Sarah and I are part of Becker's staffing group practice. Becker is a national law firm with offices located along the East and West Coast. We currently provide legal services to between 125 and 150 staffing firms nationwide in all areas affecting staffing firms, from employment law to corporate governance, contract drafting, negotiation, commercial litigation, and mergers and acquisitions. Today, we are happy to present information on employee handbooks and poster requirements. Please feel free to ask any questions you may have at any time during the presentation. So let's go ahead and get started. So what is the purpose of an employee handbook? An employee handbook serves multiple purposes. First, it serves as an employee's introduction to the company through setting expectations of the employee and the employer. Further, it sets the tone of your culture. It informs employees what will and what will not be tolerated, the benefits to be provided, and the legal obligations of the parties. Perhaps most importantly, it provides reporting mechanisms which can serve as defenses to lawsuits and possibly have you removed from those lawsuits. Finally, it serves as a baseline for all employees, including your HR team, to refer to when a personnel question arises. Thus, a uniformly applied policy could save a great deal of time and expense. So what goes into your handbook? The great thing is you get to decide. There's no hard and fast requirement that you even have a handbook. Rather, it's a document that you create to set your own culture. Thus, every handbook can really be personal to the company itself. With that said, there are, of course, certain policies you want in your handbook, such as anti-harassment policies. A lot of these policies should be a reiteration of the law or forms you may provide during onboarding. While this may seem duplicative, it can serve as a strong basis to show you went out of your way to ensure your employees were clearly aware of the policies and the laws. Also, while it may seem obvious, you wouldn't believe how many times companies forget to ensure that their employee actually signs the handbooks and that the company actually receives the acknowledgement. Please don't forget this, or you could lose a possible defense that you may have had in a lawsuit. I'm now going to turn it over to Sarah to talk about the first policy.
Thanks, Chris. As Chris said, I'm just going to go over some of the most critical policies that you should always include within your handbook. So the first one I'm going to talk about is disclaimers. While a disclaimer is not technically a policy, this provision should be on the first page of the handbook's cover, and it should clearly state in easy-to-read language that the policies in the handbook are not intended to create a contract. Rather, all employees will remain at will unless the employee's written agreement explicitly states otherwise.
Sarah, quick question.
Sure.
To make sure we're all on the same page. How is an at-will employee defined?
So an at-will employee means that either party is free to terminate the employment relationship at any time. This is without notice and without reason. Now, there should also be a provision that the current handbook, the one that's, going to be signed, supersedes all prior policies issued, so as to avoid any confusion as to which handbook applies. Finally, it should be made clear that the chief officer and management of the company, depending on the structure of your company, may change the policies with or without notice to the company's employees. It's very important. So the second policy I want to talk about is the equal employment opportunity policy. So in a handbook, it's very important for the company to state that it is committed to the principle of equal employment and anti-discrimination pursuant to Title VII of the Civil Rights Act, which was amended by the Equal Opportunity Act of 1972, as well as each state's law against discrimination. For instance, the handbook should state clearly that the company will not discriminate on the basis of any characteristic protected by state or federal law.
Sarah, can you provide a couple examples of what a protected characteristic is?
Sure. So some of the most common examples of protected characteristics are race, religion, disability, and gender. Now, the handbook should also state clearly that decisions regarding the hiring, promotion, transfer, demotion, and/or termination are based solely on the qualifications and performance of the employees or prospective employees, and not on any of the protected classes that I just gave examples of. If an employee or prospective employee feels that they have been treated unfairly, the Employment Handbook should state that they have a right to address this concern with the company's Equal Employment Officer. The company's Equal Employment Opportunities Officer should be clearly named with all relevant contact information right in the handbook so that employees know exactly who to report to. It's also a good idea to have a backup or alternative person also named in the Employee Handbook in case the complaining party has an aversion to reporting to a specific employment opportunity person. So the next critical provision that should always be in a handbook is in regards to the Americans with Disability policy. So the company must also state that it does not discriminate based on disability or any perceived disability, and that the company will endeavor to make every work environment handicap accessible, and all future construction and renovation of facilities will be in accordance with applicable barrier-free federal and state regulations and guidelines. For example, the handbook should clearly state that the company will make reasonable accommodations to known physical or mental limitations of all employees and applicants with disabilities. It should also state that it will provide that the individual is otherwise qualified to safely perform the essential functions of the job, and as long as the accommodation does not impose undue hardship on the company. Again, just like I talked about previously, the company's EEO officer and an alternative person should be named in the employee handbook and should be the one the employee reports to and engages in their dialogue with if there's any kind of complaint. However, as an employer, you are free to leave the determination of whether a reasonable accommodation can be made up to management.
Can you provide a quick example of what a reasonable accommodation would be?
Sure. So a person with a back injury may need the accommodation of having the option to stand or sit at their desk. This should not cost a great deal to the company, and in all likelihood, this would not be seen as unreasonable or would be a creation of hardship.
Thank you.
Yep. I also just want to make clear that if employees are assigned to a new position as a reasonable accommodation, they will receive the salary for their new position. That should be in a handbook so that the employees, know exactly what they're getting. You may also want to add that the Americans with Disability Act does not require the company to offer permanent light duty, relocate essential job functions, or provide personal use items such as eyeglasses, hearing aids, and wheelchairs. Additionally, I just wanted to touch very briefly on the now trending issue of medical marijuana. Employers should be aware that each state interprets medical marijuana use differently. For instance, Massachusetts protects the use of medical marijuana, while California and New Jersey don't. This is a big issue right now, and if you want to learn more about this or wish to speak to me or Chris in any further detail, you can please feel free to reach out directly.
Thanks, Sarah. And then the next policy we'll talk about is the anti-discrimination, anti-harassment policy. This is probably one of the most important, if not the most important policy that you want to have in your handbook, as it may provide a company a way out of a lawsuit if an employee fails to follow it. The first step is to define what harassment is. As a general rule, harassment is not actionable, only harassment based on a protected characteristic, which Sarah spoke about earlier. For instance, I may single everyone wearing a red belt out and decide to terminate them all one day. But just because they were wearing a red belt doesn't mean that they have an actionable harassment claim, as it's not a protected characteristic.
Now, Chris, just so I can be clear, in regards to the example you just gave with the red belts, I understand that if everyone's wearing a red belt, that doesn't make the cut. But what if it was you singled out all women wearing red belts? Does that make a...
Yep, so that would be under a different theory. That would be discrimination based on what's called a disparate impact. So you have a hostile work environment, which is created because of somebody's gender, race, religion. Then you have a disparate impact where maybe a neutral policy or neutral firing, if you will, has an impact on a protected class, in this case, women.
Sure.
And then also you want to provide a definition of what harassment is. For example, harassment can take many forms. It's not limited to words, signs, jokes, pranks, intimidation, physical contact, or violence. It's not necessarily sexual in nature either, and doesn't always refer to gender or sexual orientation. Rather, it can be directed at any personally protected characteristic of a person. It also includes any displays or circulation of degrading written material. Further, while it's a little more difficult to define, you must also have a definition of sexual harassment. The following discussion is strictly for your guidance and as an example. It's not intended to be the sole definition of the term. Sexual harassment includes, but is not limited to, unwelcome sexual advances, requests for sexual favors, and/or other verbal or physical conduct of a sexual nature when submission to or rejection of this conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment. Likewise, displaying any kind of adult materials in the workplace or using your computer network would create or would constitute sexual harassment.
So Chris, just because, that definition, it was a lot, and you said yourself that sexual harassment is hard to define. Could you give me an example of what you could put, a policy that you could put in the handbook that covers, all of that in regard to sexual harassment?
Yeah, a real quick policy statement would be all employees, female or male, will be permitted to work in an environment that's free from all forms of unlawful discrimination and harassment and conduct which could be considered harassing, coercive, disruptive, including sexual harassment, that the policy will be strictly enforced, and that you want a statement basically stating why, such as it debilitates morale and interferes with work productivity and will not be tolerated. On the sexual harassment front too, it's important to note that it's not just based on sexual comments. It can also be based on someone's gender. So sexual harassment has two meanings. It has the meaning that everybody thinks it means, that you see in the movies all the time, that is in the news all the time. Think Matt Lauer with his little red button. That's sexual harassment. Then you also have the sexual harassment which is just based on gender, which is kind of what Sarah and I just spoke about with the red belts. While that was a disparate impact, but if I was just degrading to women and not sexual in any means, then that would be sexual harassment as well, because sex and gender are almost synonymous with each other. With regard to your workers, you want to make sure that your supervisors are required to report and take appropriate action if they witness or become aware of any potential harassing conduct. They can have personal liability, so they should be made well aware of that fact. You should encourage and even give education to your employees to report any kind of harassment. Some states even require bystanders training these days, like New York City does have that. Also, like Sarah spoke about earlier, you want to have multiple avenues that they can report instances of sexual harassment. For example, you want to have emails, hotlines, direct phone numbers, just more than one person, so the person can't say that they felt intimidated by reporting it. And you should make clear, try to make them comfortable that it will remain confidential to the maximum extent it can be. Obviously, you're going to conduct investigations. You're going to have to talk to other people. So it's not going to stay fully confidential, but you want to make them comfortable enough that they actually do report it. And also, you want to make sure that they have an anti-retaliation provision for good faith reports of alleged harassment or providing truthful information during an investigation.
Now, Chris, can I just interrupt you real quick?
Yeah.
You said good faith reports. How often do you see like a bad faith report, or in what kind of situation would that occur?
I think you don't really know. I think it's probably more on the rare side, just because these things don't usually go to trial, so it's never fully fleshed out. But there are cases where you have a feeling that it was just a disgruntled worker who may have a personal vendetta against another worker who may allege impermissible conduct. That's why conducting investigations and documenting every step of the way is so important, looking at past emails, write-ups, what have you. If you don't do that, you're not going to have the paper trail, and it's going to end up being your word versus somebody else's. Sure. In this regard, training should also be provided. A lot of states are requiring training to be provided. Some states differentiate between employers or employees and supervisors. In some states, supervisors are required 2 hours of training per year, while employees are required 1 hour of training. This is especially important in the staffing industry too. For instance, California, for temporary workers, within the first 30 days or first 100 hours of working, they have to undergo training. So you have a very tight margin where other laws only require within the first 6 months or the first year. So you have to be aware of what state you're in order to comply. Also, you should definitely distribute this policy separate and distinct from this handbook, at least on an annual basis, and post it on all company bulletin boards. And finally, a lot of the new laws are requiring that you notify the employees of their legal rights in your policy. So where they can go to file complaints, whether it be Division of Civil Rights, the EEOC, courts. Unfortunately, employers do have to put it out there, even though it kind of feels like you're welcoming a lawsuit. The next policy we're going to talk about is a whistleblower policy. With this type of policy, again, you want to invite open communication, so employees come forward with reporting possible violations of laws, regulations, or public policy. In fact, many state laws and federal laws do require it. Your policy should state that employees who disclose, threaten to disclose, object to, or refuse to participate in any activity, policy, or practice that is a violation of law, fraudulent or criminal, or in contravention of public policy should report the same to the company without fear of retaliation of an adverse employment action, so long as, again, it was done in good faith. Again, these are not protected unless it's done in good faith. Also, your policy should make clear that if the employee testifies before any kind of board or court conducting an investigation, that there won't be retaliation as well, as long as they're truthful in their testimony. Again, like all other policies, multiple avenues of reporting without fear of retaliation. You can't fix what you don't know, and a lot of laws do state that they actually have to let you know before they can bring a whistleblower claim. So you want to be mindful of that. And again, you want to try to keep it as confidential as possible. Let them know that you're going to try to keep it confidential. Again, some of these things will get out there, but in some of these cases, like a False Claims Act, you might never know that there's a whistleblower claim out there until the government brings it against you. And now I'm going to flip it back over to Sarah for communication
Sure.
policy.
Thanks, Chris. Yes, I just wanted to make sure, this is a pretty trending topic right now with the era of Facebook and Instagram and all the social media, that we had a discussion on the communication media policies in the workspace. So in this regard, there should definitely be something in the handbook that states clearly that the company's communication and computer systems are for legitimate business purposes only and may only be used during working time. This should include, and this should also be in the policies, that this includes voicemail, email, and computer systems. As a result of this, and you should also put this in the policy, that employees have no legitimate expectation of privacy in regard to the systems. In this regard, the handbook should also make very clear that all communication media and all communications stored, transmitted, received, or contained through such media may be monitored by the company. And there should definitely be a sentence in there that states the company reserves the absolute right to access, review, audit, and disclose all matters entered into, sent over, placed in storage on the company's communication media. And this is okay because it goes back to what I just stated about how employees do not have any legitimate expectation of privacy. So in this regard, there should also be a statement in the policy that employees may not use company communication media in any way that is defamatory, obscene, or harassing, or in violation of any of the company's rules or policies. Some common examples of forbidden transmissions or downloads include sexually explicit messages, unwelcome propositions, ethnic or racial slurs, or any other message that can be construed as harassment, as Chris brought up, or disparaging to others based on their actual or perceived legally recognized protected class. It should also state in the handbook that employees may not install or modify any hardware, software, device, application, program code, or any sort of code without the express written permission from management. So if they're seeking to install anything, download anything, they need to get management's approval first. And obviously, employees must not reveal or publicize confidential company information. Now, another good provision to include in the handbook in this regard is that employees are not permitted to post on any bulletin board or any other posting accessible via the internet about the company or on behalf of the company, again, unless it's first approved by management. So all of this, if there's management approval, could be a different story, but normally, like I said, I want to emphasize that employees have no legitimate right, no legitimate expectation of privacy. Also, I want to make clear that to the extent that employees do use social media outside of their employment, and in so doing so identify themselves as a company employee, or if they discuss matters related to the company on a social media site, they must add a disclaimer on the front page which clearly states that their post does not express the views of the company itself, and that the employee is expressing only their personal views. This is very important. For example, they can post a disclaimer that simply says, the views expressed on this website are mine alone and do not necessarily reflect the views of the employer. However, it must be emphasized that even if an employee does make such a disclaimer, if they choose to post information on the social media site in violation of a company's policy, federal or state laws, then the disclaimer will not shield them from disciplinary action.
Sarah, can you just clarify by way of example what you just said? I think the audience may be a little confused as, on the one hand, we are telling employees they must put a disclaimer out there, but on the other, we're saying they may still be disciplined for posting it even with the disclaimer.
Sure. So employees are protected under the National Labor Relations Act from certain speech about the employer. For example, disgruntled employees discussing pay rates will likely be protected under the NLRA. Meaning an employer may not take an adverse action against the employee for doing so. And that's what I said, that it's their expressed beliefs, it's their views. However, if an employee posts confidential information about the company, so that's company information rather than, their personal beliefs, regardless of any disclaimer, they can be terminated, and they likely will be terminated by the company.
Makes total sense.
Thanks. And just one last thing in this regard, it should state in the handbook that nothing in these policies is designed to interfere with, restrain, or prevent employee communications regarding things like I said, wage, hours, or other terms and conditions of employment that is protected by the NLRA. Thank
you.
So Chris, I think you are going to talk next about pay schedules and the work week.
Yes, thanks. So work week and pay. Most states do require these notices to go out anyway, but it's always good practice to have them in your handbook just so you can double back or as a backup plan. The policies should clearly define the company's work week. For instance, is it Monday through Sunday? Is it Sunday through Saturday? So employees know their work weeks, and when to pay overtime if it's applicable. Also, you should define the hours of operation. Is it 8:30 to 5:30? Is it 9:30 to 5:30? You want to make sure that they know when they're working. Also, the paydays must be set forth and adhered to, and the employee should be advised of the wages each payday will encompass. What do I mean by this? It means, so hourly employees may be paid differently than salaried employees. For example, hourly employees may be paid through last Friday, this current Friday, whereas salary employees may be paid currently through the current Friday. Finally, you want to just put a clause in there that all federal and state withholdings will be withheld from each paycheck in accordance with law or any kind of other agreement that you may have with the employee, so long as it is lawful. The next thing I want to talk about is overtime. You clearly want to define who is an exempt and who is non-exempt employee. You actually have to notify them at the time of hire whether they will be exempt or non-exempt.
Chris, can I just interrupt for 1 second, just because I think it's important, especially in regard to overtime payment. Yep. What qualifies as an exempt employee and non-exempt?
So to be exempt, you need to be a salaried employee in most cases. There are a few exceptions, but you have to meet the minimum salary thresholds, which probably will change in the next couple months, or at least looks to be changing in the next couple months. They should be, really it's for white collar positions, so professionals, doctors, accountants, CPAs, people who are professionally licensed, or managerial people, executives. And then non-exempt is really more clerical, administrative, industrial, more blue collar. So if you're a professional, if you're working in an office, you may be exempt. If you're out on the road doing construction, unless you're a foreman or supervising other people, you're probably going to be non-exempt. And also, if you guys have any questions, whether an employee may be exempt or non-exempt, feel free to reach out to us. Also, the policy should state that overtime for a non-exempt employee is paid only for those hours in excess of 40 hours per week, of which the employee actually did work. What do I mean by that? So if an employee works in a week, let's say they work 40 hours in 4 days, but one of the days they were off. So the Monday they were off, Tuesday through Friday, they work 10 hours a day, 40 hours. So that first day does not count as overtime towards their overtime calculation. So while they're going to be paid for 48 hours, they only actually worked 40 hours, so you're not paying any overtime. Same thing for paid holidays. Overtime, obviously, is calculated at time and a half. You want to make sure that they know that it's at their regular rate of hourly pay. You probably want a provision in there too, stating that any overtime must be authorized by the employee supervisor, and that working any unauthorized overtime is strictly not permitted, and that the offending employee may be subject to discipline, including discharge. That's the only thing you can do to the employee. You're still going to have to pay them if they work overtime, even though you didn't approve it. Discipline is the only repercussion that they have under the law.
So Chris, just so I can be clear, so even if they didn't get approval and they worked the overtime, you would still have to pay them for? Yes,
if they actually did perform work, you can show that they can show that they did. I mean, they can't. We just had a client that a supervisor and a client or a worker were in a scheme where they said they worked 70 hours a week, but the records show, the videotape showed they only worked 40 hours a week.
Oh, no.
So yes, you want to be careful there. Make sure you have people you trust. Again, I just want to make it very clear that you put a provision in there, probably in bold, saying that any paid time off utilized by an employer provided by the company shall not count toward hours worked when calculating overtime pay. The next topic is paid time off. This is trending right now because of the earned sick leave. States are requiring, in some instances, up to 9 days, shouldn't say states and cities, up to 9 days of paid leave per year, or sick leave. However, if you already provide an equivalent paid time off, you will likely already be in compliance, so it won't affect you. It's typically 1 hour for every 30 to 40 hours worked, depending on what state or city you're in. The uses for this kind of leave are typically the same reasons as FMLA leave and domestic violence leave. Also, you really, in most cases, do not have to pay out any of this leave at the time of termination, but that has to be put in to your policy in order for that to be effective. So if you don't do that, you may get hit for paying out when you otherwise wouldn't have to be paying them out. Same things for vacation and personal leave. If you don't put in there that even though it's accrued, or any unused accrued vacation or personal leave will not be paid at the time of termination, states do require you to pay it out.
So the default is to pay it then?
In most cases, yes. Then we have a leave of absence. So this is your typical FMLA and state mandated leaves, which we'll talk about in a little bit too. It's also your military leave under USARA. I just want to mention one quick thing on this. The reason that this is on here is the unpaid approved leave. That you're going to give unpaid approved leave for personal reasons, but they have no job protection and no accrual benefits while they're on the unpaid leave. This should say that it's clearly discretionary and up to management. I say I say that I think this policy should be in there because of the Americans with Disabilities Act. There are cases and laws out there that actually state that leave is a reasonable accommodation. The amount of leave is wholly dependent on the situation and is still evolving through the courts. Some courts say, 3 months, some have said up to 2 years. So you really don't know. So you want to at least have that option on the table and not take it off. That does not, I want to make, again, very clear that it does not mean you cannot terminate a person if he or she would have been terminated anyway if they're on leave. So if you have a documented trail that you were planning on terminating this person maybe gets wind of it. So they don't show up for work on Monday and they tell you they're at the doctor. Then suddenly they have a disability. Maybe it's depression, anxiety, what have you. If you fire them while they're out on this leave, on ADA leave or any kind of leave subject to disability, there is a presumption that they were fired because of the disability. However, if you can show that you planned on terminating them prior, you should be able to get out on summary judgment, but not if you haven't documented it.
Chris, can I just interrupt you? So what you just described, that's a good example of how there's no job protection, because that was one of the first things you said. There's no job protection while you're on leave, and that's how you can prove that by having good documented records.
Yeah, documentation in all these instances. Whenever you're going to plan on taking any kind of adverse employment action, you really want to have it documented. You may think you have the best employees. I had a client one time, he thought he was untouchable, thought this one employee was his best friend. It ended up not working out, just wasn't a good salesperson. I'm sorry, I shouldn't say best friend, just thought he was a really good worker. And, you live and learn type thing. So that's how it goes. And the last one that I want to talk about real quick before we get to federal posters, which has been trending and frankly, it's probably long overdue, is the lactation break policy. While it's not on here, the policy should provide that a reasonable amount of break time or amount of time required by state law to accommodate a female's need to express milk for the employee's infant child for at least up to 1 year following the child's birth or as required by state law. The policy can state that break time should, if possible, be taken concurrently with any other break time. You can also have them clock out for it if it doesn't run concurrently with their break time. However, in all instances, you should definitely make a reasonable effort to provide the employee with the use of a room with a lock on the door or other location in close proximity to their work area, not a bathroom, where the employee may express milk in private. And now I'm going to flip it back to Sarah for the federal poster discussion.
Thanks, Chris. So I'm just going to go over a few of the most critical federal posters that must be posted in the workplace. And it's also important to discuss where these posters should be placed. They need to be somewhere that is visible to all employees. I've seen this in the break room, in copy rooms, just somewhere that the employer can ensure that they will be viewed by all employees. And again, just like the policies I spoke about earlier, I just want to emphasize that these are the most critical posters. They're not an exhaustive list of all the posters that must be posted. So one of the first very important posters that must be posted is Employee Rights under the Fair Labor Standards Act poster. This poster addresses FSLA minimum wage, overtime pay, record keeping, and youth employment standards affecting full-time and part-time workers, and that's in the private section, and government workers. The next poster that you must post, and you'll see commonly, is Job Safety and Health. It's the law poster. And this is the OSHA poster. It requires employers to comply with occupational safety and health standards issued by the Occupational Safety and Health Administration, and also to provide employees with a workplace that is free from recognized hazards that are causing or likely to cause death or serious physical harm. Another very important poster is Employees' Rights and Responsibilities under the Family and Medical Leave Act, and this touches upon some of the topics that Chris already mentioned. This is FMLA, and this provides an entitlement of up to 12 weeks of job-protected unpaid leave during any 12-month period to eligible covered employees. And this covers the birth and care of eligible children, the care of immediate family members, and most of the time oneself. There are some exceptions to that.
Yeah, and I just want to add real quickly,
Sure.
there's also a military leave provision in there,
Yes.
even though we'll talk about that totally, you, Sarah, on a totally separate topic, but FMLA does have a military
Yes, it does.
leave provision.
Thanks, Chris. Another poster that I wanted to mention is the pay transparency non-discrimination provision. And this is in regard to federal contractors only. And this is that the contractor will not discharge or in any other manner discriminate against employees or applicants because they have inquired about, discussed, or disclosed their own pay or the pay of another employer applicant. However, subject to limited exceptions, employees who have access to the compensation information of other employees or applicants cannot disclose them, and that's pretty standard. Yeah. Another big one is migrant and seasonal agricultural worker protection notice, and this requires farm labor contractors, agricultural employees, and agricultural associations who recruit, solicit, hire, employ, transport, or house agricultural workers, as well as providers of migrant housing, to meet certain minimum requirements in their dealings with migrant and seasonal agricultural workers. That one's pretty specific, but worth mentioning. Another one that I find interesting is the Employee Polygraph Protection Act Notice, EPPA. And this prohibits most private employers from using lie detector tests, either for pre-employment screening or during the course of employment. Another big one is Your Rights Under ERISA poster. And as Chris mentioned before with ERISA, this requires employers to provide employee notice of their rights, benefits, and obligations under ERISA. ERISA. Employees, Sarah. I'm saying ERISA. Sarah. Employers may provide the required notice by distributing it or posting it where employee notices are customarily placed. Now, Chris, I know there are some specific Massachusetts posters. Yep, maybe you can say the acronyms right. That would be good.
No worries. So the first one we'll talk about is, the Massachusetts Wage and Hour Laws poster. This encompasses minimum wage, tips, overtime, payment of wages, pay stub requirements, pay deductions, meal breaks, your payroll records, sick leave, non-discrimination, and small necessities leave. It's similar to FMLA dependents, or similar to FMLA for dependents. The next one is the Fair Employment Law poster. It protects applicants and employees from discrimination in the hiring or promotion, discharge, compensation, benefits, training, classification, and other aspects of employment on the basis of protected characteristic. Again, you can see that protected characteristics are very prevalent throughout states and federal. It also prohibits harassment, prohibits criminal history inquiries. So the criminal history inquiry specifically states the law prohibits employers from asking applicants on an initial employment application for any criminal background information unless an exemption by statute or regulation exists. There's also a mental health facility admission inquiry that employers may not refuse to hire or terminate an employee for failing to furnish information regarding his or her admission to a facility for the care and or treatment of a mentally ill person. An employment application also may not seek this information as well. Oops, sorry. So the next one is the Parental Leave Act. Again, this is very similar to FMLA or an offshoot of FMLA. The law requires employers with 6 or more employees to grant an employee who has completed an initial probationary period and has given 2 weeks notice of an anticipated date of departure and the employee's intention to return at least 8 weeks of paid or unpaid leave for the purpose of childbirth, adoption of a child under 18, or an adoption of a child under 23 years old if the child has a mental or physical disability. The next one is information on employees' unemployment insurance coverage, and this is typical for all states, not just Massachusetts. You have to let them know, your workers know that they may be entitled to unemployment insurance benefits, and you have to inform them how to go about applying for those benefits. Similar to that is the workers' compensation poster. It sets forth It should set forth the name and address of the insurance company for any cases arising out of personal injury in the course of employment. It must have the policy number, must have the name and contact information of the insurance agent, name of the employer and employer's workers' compensation officer. Now, we touched on earned sick time a little bit before, but for Massachusetts, it's 1 hour of sick leave for every 30 hours worked, and they may earn and take up to 40 hours of sick leave a year. However, that may be rolled over, so you may conceivably have 80 hours in 1 year in your bank, so to speak. You only have to let an employee use 40 of those hours. So it's kind of...
So it's capped at 40. So you could have 80, but it's capped at 40.
Yes. So it will always be capped at 80 because you're only allowed to roll over 40, but you only have to permit 40 hours used. So
it seems a little more generous than it actually is.
Yeah, and if you have the non-payout at termination provision in there, then again, it's just you bank nothing, really. So you're getting no benefit from it. So you really use it or lose it at that point.
Now, if you don't have that specific provision in the handbook that you're not going to get paid for all accrued, if there are 80 accrued in there, could you be paid for all 80?
Conceivably, yes.
Wow.
The provision also states that employees begin accruing sick time on the first day of work, but they don't have to have access to it until after working 90 days. They can use their sick leave, again, typically for the same reasons that we've already talked about, for their child, their spouse, the parent, the spouse's parent is sick, injured, or has a routine medical appointment, to use it for domestic violence for themselves or other people. They also have to provide notice unless it's an emergency. Employees who miss 3 or more days in a row need to provide a doctor's note. So it's not, the employees just don't have free reign here. They do have somewhat, but only after 3 days. If they don't provide the doctor's note after 3 days, there are actions that you could possibly take. So it's not fully protected, not fully one-sided, even though it does appear that way. And then you have, not all of it has to be paid, though. Only employers with 11 or more employees have to provide paid sick leave. If you have less than 11 employees, it doesn't have to be paid. It can be unpaid leave. And then we have the job safety and health poster. It's the same poster as OSHA, so I won't get into that. And additionally, relevant to this call, I'm now going to turn it back to Sarah for the temporary worker right to know.
Right, so this is relevant to this call, and this is a Massachusetts poster about the temporary workers' right to know, as Chris said. So this law requires staffing agencies specifically to give employees a written notice with basic information about any job to which they're sending their employees. Employees have a right to tell the staffing agency how they want the employer to give the job order, such as by email, mail, or to pick it up in person. Staffing agencies must give at least this information that I'm just going to briefly touch upon because I think it's important. The name, address, and telephone number of the staffing agency, the workers' compensation carrier, the worksite employer, and the department, DLS, a job description and whether the position will require any special clothing, equipment, training, or licenses, the pay day, hourly rate of pay, and whether overtime pay may occur. As Chris touched on, this is very important. The start date, daily starting time, and anticipated end time, if known, and if known, expected duration of the employment. Whether any transportation or meals shall be provided by the staffing agency or worksite employer. Any charges to the employee or worker. Whether the worksite location is on strike or lockout. And a multilingual statement that the job order contains important information concerning the work, employment, engagement, work assignment, or job. The staffing agency can give the job information over the telephone, but it must send the information in writing before the end of the first pay period, so it's time sensitive. Also, if the job assignment changes, the staffing agency must tell the employee about these changes as soon as it knows about them. Again, time sensitive. Now, if the staffing agency does not provide a job order and the employee would like to make a complaint against the staffing agency, the number of the Department of Labor standards must be provided to the employee. The staffing agency cannot retaliate just because a complaint was made. If placed in a professional position or as a secretary or administrative assistant, the staffing agency does not have to provide a job order. So just keep that in mind. So that's distinguished from what I just stated. And that's for, again, professional positions such as a secretary or administrative assistant. Now, the only other poster that I think is relevant is the domestic workers' rights. Not relevant, but important to know, applies to household workers such as housekeeping, childcare, elder care, et cetera, who work more than 16 hours per week. And in that case, a contract is required. And I think that's it for me.
Yes. We can open up the Q&A right now, but I did want to touch upon one thing. There is for the non-exempt employees, which most of your workers are going to be, you really want to make sure that there's a good timekeeping system and that you have that type of policy in there where possibly the client signs off on it or your on-site supervisor signs off on it. I've seen a lot of times where there's discrepancies and, I'm sorry, we have a question. Discrepancies between what they worked and what they say they worked. It just creates a wage claim. You might get audited. You want to stay away from that. So if you have any kind of electronic system, you want to go for that. Will the slides be sent out afterwards? Yes, they will. After this is over, within an hour? Yep, within 1 hour.
And if I can just say one more thing as well, and it's just something that you touched upon in the very, very beginning, and I just think it's important again. So all of these policies that we talked about are very important, but you must have your employees sign the handbook.
Okay.
You don't understand how many times a great employee handbook is drafted with all these policies that we talked about, and they're either not distributed to everybody or they get distributed and there's no follow-up, and then, something happens. You go to pull out the policies and they weren't acknowledged.
Yeah, and I do, just to kind of follow up on Sarah too, these aren't by any means the only policies that you should have in there. These would probably be, honestly, about maybe at most a quarter of the policies that you should have in there. But again, it's going to depend on your company and what you feel comfortable with. And you may also have two different handbooks, one for internal employees and one for your temporary workers too. So that's it for us, unless anybody has any questions. We have one more. How often do handbooks and policies have to be signed? I'll read it again. How often do handbooks and policies have to be signed? It's really every time you revise it, obviously. There's certain policies like the anti-discrimination, anti-harassment, and whistleblower policies that should be signed each year. There's also state requirements that certain policies be signed, at least on an annual basis as well. And it's probably always good to have a refresher every couple of years if you haven't made any changes. But if you haven't made any changes in your handbook in a couple of years, you probably waited too long, because the rate that the employment laws are changing, especially for the benefit of the employees, not really for the employers, it's hard to keep up with. I would say at least look at your handbook to see if it should be revised every couple of years at the very least. You're welcome. All right.
I think I'm good. I don't think I have any more comments.
All right. Well, thank you, everybody, for attending. If you have any questions, feel free to follow up directly.
Hold on. I think there might be one more.
Do you have to have a temp handbook? No, you do. So the question is, do you have to have a handbook for temporary employees? No, you don't have to have a handbook for anybody if you don't want to. But it's I want to say this nicely, it's your funeral. If you don't at some point, you don't necessarily need a handbook, but you should definitely have these policies handed out at onboarding. It should act.
Safety net.
Yeah, safety net. There you go. That sounds better. But so if you don't want one for temporary employees, that's fine. But you definitely want to still have the anti-harassment policy in there. Any policies that are required by state law. I keep saying the anti-harassment one because, with the Me Too movement,
it's big right now.
Yeah, if you don't have it, it could be your only defense out of a lawsuit where you escape a liability, and the liability is only against the accused. If you don't have it, you could very well have joint liability, and you could end up costing the company what, 100, 200, 300, 400. I've seen up to $400,000 in attorney's fees just to fight the case, and you may win it, but you just spent $400,000 to win it, so it's not necessarily worth it. And you're welcome. All right. If nobody else has any other questions, we're going to sign off, and you guys can feel free to email Sarah or I. And we thank you for joining us, and hope to talk to you soon. Thank you.
Thank you.